So I'm going to record this. So in terms of the constitutional principles that you did a wonderful job enumerating in your discussion groups and your reporting. Uh, this is my summary as well. Um, I found in the cases in the four, and this is based upon the four cases, um, that there are a number of principles in these cases that are consistent with what we have referred to as the constitution of knowledge. Uh, One of them, one is a governance, and these principles related, the principles of the Constitution of Knowledge as it relates to school policy, educational policy. One principle is what we could call the governance principle, that local school boards have broad discretion regarding the curriculum as well as other educational policies. However, there's a limiting principle as enumerated in these cases in the majority opinions that the exercise of this discretion must be within the imperatives, must stay within the imperatives or be consistent with the imperatives of the First and 14th Amendments, as well as the entire Bill of Rights. And here are some quotes from Tinker and also from West Virginia Board of Education versus Barnett, which was a often cited precedent in these cases. Students do not, quote, shed their constitutional rights to freedom of speech or expression at the schoolhouse gate, quote. The exercise, the authority, the school board does not include the authority to prescribe, quote, prescribe what should be orthodox in politics, nationalism, religion, or other matters of opinion, end quote, from West Virginia Board of Education versus Barnett. And further, boards of education have, of course, important, delicate, and highly discretionary functions, but none that they may not perform within the limits of the Bill of Rights. That they are educating the young for citizenship is a reason for scrupulous protection of constitutional freedoms of the individual. If we are not to strangle the free mind at its source and teach youth to discount important principles of our government as mere platitudes. That was from Justice Jackson. So there's a fundamental principle of governance and fundamental principle of limiting the discretion of school boards in terms of the Bill of Rights, which includes a right to freedom of thought and inquiry. A precedent was from Griswold versus Connecticut. The state may not contract the spectrum of available knowledge. And Justice Jackson in Barnett, well, that's the quote I just read. So Jackson also in this statement illuminates the function of the 14th Amendment, or part of the 14th Amendment. A part of the 14th Amendment stipulates that the Bill of Rights is applicable to state law, which would include the actions of a local school board. So a right to freedom of thought and inquiry is established, is enumerated and affirmed in these cases. Of course, as we just discussed, a right to freedom of expression, in particular political expression in schools, is also affirmed in Tinker. And this quote is what Shatranjan read earlier in the summary of Tinker. So Tinker establishes and it's an established precedent of freedom, a right to freedom of expression that should be robustly protected by the Constitution. A fourth, another principle is the right to receive ideas. This comes out of Pico. That there's among the majority opinion, there's a right to receive ideas. And this is also expressed in Tinker, upon which PICO is based, the precedent set by Tinker, which stated, the majority in Tinker stated, the vigilant protection of constitutional freedoms is nowhere more vital than the community of American schools. The classroom is peculiarly the marketplace of ideas. The nation's future depends upon leaders trained through wide exposure to that robust exchange of ideas, which discovers truth out of a multitude of tongues, rather than through any kind of authoritative selection, end quote. What follows is a right to freedom of expression, the right to receive ideas, to be exposed to a robust exchange of ideas in school follows from the right to freedom of expression, as well as political freedom, as expressed in PICO. There's also a basic principle of rejection of political authority in settling the truth in all four of the cases, as well as various precedents. And in this principle, the state may not impose ideological discipline. The state may not suppress exposure to ideas. The state may not deny access to an idea simply because officials disapprove of it or dislike the idea, and that the state may not coerce a preference among beliefs, which is the majority ruling in Abington. And these quotes are from precedents and as well as Tinker about the rejection of political authority in the realm of settling the truth. Very powerfully stated in Barnett, if there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion. In Kizian versus Board of Regents, the First Amendment does not tolerate laws that cast a pall of orthodoxy over the classroom. In Tinker, the majority wrote, state-operated schools may not be enclaves of totalitarianism. Students may not be regarded as closed-circuit recipients only of that which the state chooses to communicate. And then again in Barnett, the very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials. So it's a very established principle here that that sheer political authority is not a justifiable method for determining the truth and for settling belief. Another basic principle is the right to academic freedom, and this was expressed in Abington. One could ask, at least from the majority opinion, which is open to debate, that in order to qualify for the protection of academic freedom, a knowledge claim must be a legitimate area of inquiry governed by the Constitution of Knowledge. So a right to academic freedom pertains to knowledge, genuine knowledge claims. Whether creation science qualifies is an open question. There's also finally an educational principle that's a basic educational principle expressed in these cases, that authentic education entails a robust exchange of ideas and therefore is counter to or converse with shielding students from certain ideas that are viewed by officials as politically distasteful. So these principles are there in the case law of the Supreme Court, and I think they comport well with the basic principles of the Constitution of Knowledge, as well as being consistent with the basic elements of fairness. So this, in particular, schools are and educational policies fundamentally important in this realm because schools are one of the primary institutions for the creation and dissemination of knowledge in society, and therefore are prominent, should be governed by the principles of justice that are legitimate for determining what the truth should be, or what the means of settling belief is. Okay.